This is case number 16 CR 196, State of Tennessee versus Gary L. Simpson. General, if you'll make an announcement as to what we're doing here today.
Governor, we've reached a plea agreement. Paperwork's before the court. Mr. Simpson will plead to count one, which is especially aggravated kidnapping, receive a 25-year sentence and 100%, $800 fine. Count two is going to be reduced from rape of a child to aggravated sexual battery. He will plead to that charge. I believe it's an Alford Plea, is that correct? So count two will go from rape of a child. He'll plead to reduced charge of aggravated sexual battery, 8 years at 100%, runs concurrent. Count three, which dealt with a episode prior to the kidnapping, will be null and for an effective sentence of 25 years.
State your full name and oath for the court.
Gary Lewis Simpson.
You understand the testimony you give must be truthful. If you give any false testimony, you can be charged with perjury.
Yes, sir.
How old are you?
I'm 58.
And what education do you have?
High school education.
Can you read and write?
Yes, sir.
Without any difficulty?
Yes, sir.
Anything about your health, physical, or mental condition that cause you not to understand what you're doing here today?
No, sir.
And normally my next question is, are you pleading guilty because you are guilty? Your lawyer says this is an Alford plea or a best interest plea under North Carolina versus Alford, which is a United States Supreme Court case. You can enter a best interest plea. Before I can accept it, you have to answer these questions correctly. You think the evidence is such that had you gone to trial, you think there's a good probability that you could have been found guilty of especially aggravated kidnapping and aggravated sexual battery?
Yes, sir.
You sincerely believe it's in your best interest to enter this plea today.
Yes, sir.
In view of everything, the sentence, the agreement, the facts, you think this is a fair disposition to you?
Yes, sir. Yes, sir.
Your agreement is for the especially aggravated kidnapping, 25 years, 100%, $800 fine. Count two, you're pleading guilty to the amended charge of aggravated sexual battery, 8 years at 100%. These run concurrent. You'll have an effective a sentence of 25 years, $800 fine plus costs. Is that your complete agreement?
Yes, sir.
All right, General, if you'll give us the facts in this case.
Your Honor, on May 4, 2016, Gary Lewis Simpson went to Hawkins County Elementary School in Rogersville, Tennessee, picked up a female juvenile under the age of 13. He told the school staff that the child's father had been in an accident and that she would probably not be in school the next day either. Mr. Simpson left the school in a 2002 white Dodge van with license plate 173 GPS. When the child did not get off the school bus at her home, her father went to the Rogersville Police Department and an investigation ensued. Prior to Mr. Simpson taking the juvenile from school without her father's permission, he was seen on video surveillance at Walmart buying clothing items, makeup, child's camping chair, child's girl's swimsuit, underwear, and other items. A subsequent surveillance video showed both Gary Simpson and the child buying food items at the Save-A-Lot grocery store in Rogersville immediately after picking her up from the elementary school. When neither the child nor Mr. Simpson were located by the next day, an Amber Alert was issued for the juvenile, and a nationwide manhunt ensued. It involved the FBI, the TBI, the Rogersville Police Department, the Hawkins County Sheriff's Office, and other law enforcement agencies across 19 states, as well as the public at large. On May 12, 2016, 8 days after the child was taken, dispatch received a call from a citizen that a van matching the description had been seen in a very rural area of Hawkins County. Citizens subsequently located Gary Simpson in the vehicle with the child, and he was detained at gunpoint by the private citizen until law enforcement arrived. Later that day, Mr. Simpson was interviewed by Special Agent James Wiley of the TBI. After signing Miranda waiver and consent form, Gary Simpson disclosed that he touched the private parts of the minor child. When Gary Simpson's van was searched, a paper was discovered that could best be described as a to-do list of sexual acts, and at the bottom of the list was a threat that if anyone was told about what they were doing, they would both die along with several people that were close to the child. Your Honor, that's the statement of the facts. We'd like to enter into the record along with that statement of the facts, his statement in the to-do list that I referred to.
All right, you can file that as a collective exhibit 1. All right, Mr. Simpson, you heard all that evidence. Is that a fair statement of what the state's proof would be?
Yes, sir.
And basically, anything else you want to say?
No, sir.
And based upon your waiver of rights, plead guilty, submission of the charges to the court of proof in case number 16 CR 196. I find you guilty in count 1 of especially aggravated kidnapping. Sentence you to serve the maximum sentence of 25 years, 100% release eligibility. Fine you $800. In count 2, I find you guilty of aggravated sexual battery, a class B felony. Sentence you serve 8 years, 100% release eligibility. There is no fine on that count. Count 1 and 2 are concurrent. Count 3, the state moves for a nollie, correct?
Yes, Your Honor.
All right, count 3 will be a nollie. You're gonna have an effective sentence. Count 1 and 2 are concurrent. The 25 and the 8 are concurrent for 25 years, 100%. Impose a fine of $800, and you're rendered infamous. You're now a convicted felon. If you ever possess a firearm the rest of your life, it's a felony. I'll give you credit for the time you've already served on this case, and you'll be cut you serve your sentence.
The reason for the reduction of the rape to the sexual battery.
Yeah, that was in order to establish penetration. It would probably have taken Carlie to have to testify, and the fact that he was already getting the time he would have gotten at the low range of that offense. Then we felt comfortable making that offer just to keep Carlie from having to testify.
And with the state good time, how much time would he actually be serving maximum?
Well, maximum was 25 years. He could get about 3.5 years, I think, credit. But generally speaking, he's probably going to serve 25 years.
Okay, why is that?
Just the nature of the charge.
Oh, okay. They don't give you good time.
Well, I just know in other cases where those charges are similar that they usually serve the whole time.
Okay. All right.